Thank you, Deputy Speaker. The Coalition was elected by a huge mandate in September 2013 to deliver strong government to guarantee a safe, secure Australia. This bill is about implementing that promise to the Australian people. I welcome common sense notions on the statute books and codifying our community values and expectations. This bill has never been more timely or more important. This bill will strengthen the government's ability to deal with unlawful, fraudulent or criminal behaviour by non-citizens. The character test has not changed significantly since 1999. Since then, the situation has changed dramatically, with streamlined processes and higher volumes of temporary visa holders for economic and other purposes. The proposed changes strengthen and widen the powers to refuse or cancel a visa on character grounds. The government will be able to act if there is a risk, as opposed to a significant risk, that a person would engage in a wide range of criminal conduct, according to the explanatory memorandum accompanying the bill. Reasonable suspicion that a person is or has been associated with a group involved in criminal conduct will be sufficient to refuse a visa. Such conduct includes people smuggling, genocide, war crimes, a crime involving torture or slavery, or a crime that is otherwise of serious international concern, even if there's no actual conviction. A person found guilty, even if no conviction was recorded, by an Australian or foreign court of a sexual offence involving a child will be out. The measure also allows the Minister to require state and territory governments to disclose personal information that may have a bearing on character. The most important point that this government wants people to take away is that entry and staying in Australia by non-citizens is a privilege, not a right. The Australian community expects that the Australian government can and should refuse entry to non-citizens or cancel their visas if they do not abide by Australian laws. I want to bring to this debate a real lived experience of what it is to be an Australian, what Australian values are. The whole issue of Australian values has become the mission of one of my constituents, Mr. Robert Suan. At first, I construed Mr. Suan's ardent fervour to hammer home the points of values education and Australian values as some sort of anachronistic and atavistic agenda. Well-meaning, but sort of unimportant. However, the more I listened, the more I realised how important the issue of values and character are to the very fabric of our society. Robert always reminds people of the riots in Cronulla in 2005, his hometown, and how many of those involved couldn't identify with our Australian notions of the good and the upstanding. One understands Robert and his motivations a great deal more when one is informed that for 70-odd years Robert has been a Boy Scout. The question for our community is, how can we take back common sense, good, wholesome, traditional values from the scrap heap of history? One very easy and effective way is to stop the dilution of those values by persons of nefarious character. There should be no shame in saying that we have values and principles, and that this coalition government is willing to stand up for them. Visas should not be thrown around like confetti. Visas should not be sold to the highest questionable or criminal bidder. Visas are a golden ticket. In my home state of Western Australia, there's a saying that fly-in, fly-out workers, or the eponymous FIFO, should really stand for fit in or fly out. Of course, that is the parliamentary version of that reimagining of the FIFO acronym. I firmly believe that a fit in, fly out approach, or Team Australia approach, should also apply to our migration program. The Migration Amendment Bill provides the springboard to get to another key idea that has gone completely off the radar, and that is the idea of rights and responsibilities. Under the previous 6 years of Labor misrule and chaotic misgovernment, the balance of rights and responsibilities became only a question of rights. Or more succinctly, a question of what can I get and what rights do I have? In the context of visas and entry to the Australian homeland, this attitude will defile the integrity of the system and our society. By turning a blind eye to gross and aberrant characters, and by accepting all in good faith, we expose our people to unknown dangers. Enoch Powell's rivers of blood may not have run, but it was because of the strong actions taken by successive Conservative governments. I'm proud to be part of a government that is bold in its actions and resolute in its decisions. Let me get back to the idea of cancelling visas, as it fits into the rights and responsibilities paradigm. It is a question of balance or an equilibrium equation. It is a case of looking at the very fundamental building blocks of what it is to be a nation and a society. Pardon me. One looks to the societal contracts of Rousseau or Locke, and there it is, line 1, to protect the bodily integrity of each citizen and of integrity of the state. Even the visual idea of the contract is relevant to this debate surrounding cancelling visas and making it easier for the minister to do so. After all, the Australian government is honouring its side of the contract or deal by protecting the bodily integrity and security of the person, but they are not living up to their side of the deal. The deal being, if one comes to this country, then one has to play by the rules as they stand. Not change the rules because one does not like the rules. The minister of the day has a direct mandate and democratic imprimatur of the people. This is more powerful than a foreign far-off institution or body. This legislation, through the increased power to the minister, empowers the people. Speaking to the specifics, the Character Cancellation Consequential Provisions Amendment will make a number of amendments to give full effect to the substantive amendments made by the Migration Amendment Act 2014. This amendment will ensure that non-citizens who commit crimes in Australia or who pose a risk to Australian society are considered for visa refusal or cancellation. This government has protected Australians by previously introducing a revocation power by the minister to personally set aside decisions by his delegates or the AAT for the national interest. The amendments to this particular bill will ensure that mandatory cancellation powers are consistent and comprehensive throughout the Act, as to enact this government's original intent of the changes made in 2014. Our primary responsibility as legislators in this place is to protect the citizens of Australia. That is our first job and priority. The changes outlined in the Migration Act Amendment Bill are the first real attempt to update the security and protection features of the visa program since the mid-1990s. The world is a different place now. The changes outlined here demonstrate this coalition government's and the Australian community's low tolerance for criminal, no-compliant or fraudulent behaviour by those given the privilege of holding a visa to enter or stay in Australia. Let me just mention the great unmentionable, the hard-working battler, the underpaid, overworked taxpayer. Having a weak or low threshold for character tests dilutes the nature of our system and costs us all more in the long run. Security is an expensive business. Prevention is always better than cure. Prevention is also always cheaper than cure. The people we seek to remove from the Australian community or ban from entering the Australian community in the first place are people that are against us. They're people that hate freedom. They hate us because we Australians love freedom. It is not just enough to have an Australian residency visa to be an Australian. One needs to live Australian, live the values, live the hopes, live the dreams. One needs to embrace the history of Australia. This bill is carrying the message of John Howard when he said in 2001, "We will decide who comes here and the terms under which they come." This government is continuing in that strong tradition of putting the Australian people first. Under Labor, the people smugglers and evildoers were first. Career criminals, drug peddlers and other such were put first. This bill will ensure the confidential information, which is critical to decision-making, will be given the same protections as other character provisions in the Act. This bill will give full effect to the policy of mandatory cancellation. It puts beyond a doubt that a non-citizen who is subject to a mandatory character cancellation decision will be removed from Australia. This bill has given this government the strengthened ability to identify non-citizens with character concerns by amending the definition of character concern to be consistent with the character test contained in Section 501. Non-citizens who meet the amended and broader definition of being a character concern may have a personal identifier disclosed in accordance with permitted disclosure provisions of this Act. This amendment has ensured that the Minister's power to cancel a visa will not be affected or limited by any visa cancellations provisions of this Act. It is this government's commitment to ensure that non-citizens who pose a risk to the Australian community are dealt with effectively and efficiently. This bill will allow the detention of a person who is reasonably suspected of being subject to cancellation, as well as requiring the release of that person as soon as the officer becomes aware that there will be no cancellation. Via this amendment, this government has also ensured that a person whose visa has been cancelled by the Minister under Section 501BA will have any outstanding visas or visa applications they hold cancelled by operation of law. The foresight of this coalition government in these bills is pulling down the shutters on the type of person setting foot on our golden soil. This should be no land of opportunity for the young criminal. We will not and cannot let this nation ever become known as a soft touch. In the final analysis, the Minister for Immigration and Citizenship has the power under Section 501 of the Migration Act 1958 to refuse a person's application for a visa or cancel a person's visa if that person fails to satisfy the Minister that he or she passes the character test. The Migration Amendment, Character Cancellation and Consequential Provisions Bill 2016 will amend the Migration Act to ensure that the substantive amendments made to the Migration Act late in 2014 are given full effect, and to ensure that the character-related provisions are dealt with consistently through the Migration Act. Not Human Rights Watch or any other limp-wristed, loony leaf-eating Luddite organisation. During the 2011-2012 financial year, 88 people had their visa applications refused and 157 had their visas cancelled on this basis. This is a paltry figure when we know that the Labor legacy is 30,000 people in community detention awaiting processing. A pathetic figure when we know that paperwork was often and regularly destroyed, forged or fabricated. I'm calling on the Minister to use these new powers with gusto. I make this call because it's what my constituents of Tangney would want, to protect the safety and security of all people of Australia, and that is the mandate that I have in this place.